will go on the record in the matter 26 CF04, State of Wisconsin versus Roberta Matrius. The state appears through District Attorney Kevin Schmidt in person. Ms. Matrius appears in person with counsel Daniel Chapman. We're set here today in this matter for a preliminary hearing. It's my understanding this will be a waiver.
That's correct.
Ms. Matrius, did your attorney go over with you what it is that the state must prove to prove your guilt or to prove that a felony was probably committed and probably committed by you?
Yeah.
And you understand that you have the right to have a preliminary hearing, or you can waive that right, but in waiving that right, you are agreeing that the state can at least meet that burden.
Yes.
You understand at a preliminary hearing, your attorney would be able to ask questions of the state's witnesses, would be able to call witnesses to testify for you. He'd be able to produce evidence on your behalf or possibly discover things about the case, which could include defenses, but you're giving up those rights today?
Yes.
You understand that
Before this courtroom session even settles into routine procedure, there's already more happening beneath the surface than meets the eye. A defendant waives a critical legal right, something that could shape the entire trajectory of her case, while a quiet but important admission about plea negotiations raises eyebrows. Then, just minutes later, we shift into a completely different case involving a suspected drunk driver with a history that could dramatically increase the stakes. And just when you think you've seen it all, the courtroom takes a deeply human turn, where accountability, second chances, and redemption collide in a powerful sentencing moment. Stay with us, because each of these cases reveals a different side of the justice system, and not all of them are what you'd expect.
by waiving the right, it means that you're waiving it forever. Do you understand that? You can't get it back.
Okay. Yep.
Has anyone made any threats or any promises to you for you to waive your right to a preliminary hearing?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes.
and voluntarily?
Yes.
As you're, okay. So I'll find that you're competent to freely, intelligently, and voluntarily waiving your right to a preliminary hearing. I will find probable cause and I will bind the matter over. Information, Mr. Schmidt.
Just so we're clear, Judge, regarding the waiver, there were plea negotiations contingent on waiving this. So when you asked her, has anyone promised you anything? Yes, there was something promised in exchange for this.
And I don't consider that necessarily a promise, but it does come into play for this. So thank you for placing that on the record. I could do your April 18th at 2:45 or April 20th at 2, or I can do a different date and time altogether.
For arraignment?
Yes. Oh, no, for an arraignment. You want to do the arraignment today or?
I would think so. Is it going to be the same charges?
I follow the information that mirrors the criminal complaint.
Yes, same charges.
So that means this is the not guilty plea that we talked about. There's a second piece of paper that gets filed with the formal charges, but he's saying it's going to be these exact charges, which we already know about. But, you know, we have to know about before pleading not guilty. I would suggest the right to say I want a different judge. So we'll plead not guilty to those then.
Yeah. What about them? They gave me a citation for the 28th for this one.
We'll talk about that in a second. Yes, we're prepared to move forward.
All right. Understands charges and maximum penalties.
She does. We will waive reading of the information and plead not guilty to each of the two charges.
Not guilty pleas will be entered on your behalf. You are entitled to a jury trial, would be entitled to a speedy trial should you request one, either your April 20th at 2 or April 18th at 2:45 or a completely separate date.
April 18th is fine.
April 18th at 2:45, April 18th at 2:45, we will see you.
April 18th.
Oh, sorry, April 18th or April 8th. I'm sorry, it's
Oh.
April 8th.
Okay.
Sorry. My
April-
L and my ones look the same, I guess.
Did you say did you think I was there on the 8th? That's for something else?
I have you April 8th. Maybe it got taken off. It could have.
I'm here on, did you say the 20th was the other one?
Yes.
I'm here on the 20th. I don't see myself here on the 8th, so let's do the
8th at
20th.
2:40. That was removed.
Okay,
Yeah, so we can do April
420.
20th. Yeah, whatever we had there is removed now. April 20th at 2.
Thank you.
All right. Anything further?
Is there also another court date for Ms. Matrius on a citation?
There
She
is
just-
not.
Okay.
I checked that and no, you're good. You're good to go.
No other court dates.
Oh, okay.
Nothing else, Judge. Thank you.
All right, thank you. Then we are adjourned.
I can get you your notice.
Glad you're doing better, Mr. Schmidt.
Saturday.
Sorry, I like him to come. I like to see him on the weekends too. I have to get better at having a little space between my L and the other things. I did that the other day too.
I think there's nothing more exciting for Morgan than to come here.
Oh, that's his birthday?
Yeah.
Oh. Yeah, he would love it.
You're like, can I make an argument?
He sure can. He can sit up here. We will go on the record in the matter 25 CF 165, State of Wisconsin versus Jeremy Brown. The state appears through Assistant District Attorney Jose Vila in person. We have Mr. Brown in person with counsel Bruce Anderson. We're set here today in this matter for a preliminary hearing. The matter is proceeding as such. Mr. Vila, please call your first witness.
Thank you, Your Honor. State calls Deputy Gavin Antone.
Deputy Antone, please come forward, raise your right hand, be sworn in, and have a seat at the witness stand.
You swear that the testimony you're about to provide today in this matter is the truth, the whole truth, and nothing but the truth.
Yes.
You may begin.
Can you please state and spell your name for the record?
Gavin Antone, Gavynanton.
Excuse me, is there a squeal coming out of something?
I don't hear a squeal.
You hear it?
I don't hear a squeak.
I hear air, we're off the record. I hear air coming out of there, but I don't hear,
I squeaked my boots off the chair. It might have been.
No, it was a squeal that I could, I can't hear it.
okay, back on the record.
How are you currently employed?
I'm employed with the Burnett County Sheriff's Office.
And how long have you so been employed?
A little more than 2 years.
Prior to today's hearing, did you review a criminal complaint in Burnett County case number 25 CF 165 as it relates to Mr. Jeremy Brown?
I did.
On November 22nd, 2025, did Deputy Bailey Mangan attempt to conduct a traffic stop near County Road U in the Oakland Township?
Yes,
Is that area located in Burnett County?
it is.
Why did Deputy Bailey Mangan attempt the traffic stop?
Deputy Mangan observed a Ford F-150 pickup truck where the passenger tires both left the roadway on the right side. And as Deputy Mangan was turning around, the truck crossed the center line, was in the opposing lane of travel.
Did the vehicle ever stop?
Eventually it did, yes.
Where did it stop?
At the Gandy Dancer Saloon,
Is that area located in Burnett County?
yes.
Did Deputy Mangan make contact with the driver?
Yes.
Who was the driver?
Driver was identified as Jeremy Brown.
And how was he identified?
Deputy Megan recognized him from previous contacts, and the truck was also registered to Mr. Brown.
Understood. Were you present when Deputy Mangan made contact with this Jeremy Brown?
I was present about halfway through Deputy Megan's contact.
So you did see Mr. Jeremy Brown on the scene.
Yes,
Do you see that same Jeremy Brown here in the courtroom today?
yes,
Could you please identify him by where he is sitting and what he's wearing?
yes. He is sitting to my right wearing a white and black quarter zip.
Let the record reflect that Deputy Antone has identified Mr. Brown.
Did Deputy Mangan speak to Mr. Jeremy Brown?
He did, yes.
What did they talk about?
Deputy Megan advised Mr. Brown the reason for the stop. And throughout that contact, Deputy Megan noted that he could smell the odor of alcohol coming from Mr. Brown, and also observed slurred speech and glossy eyes.
Understood. Did they talk about anything else?
They talked about the reason for the stop. Mr. Brown stated that he and an unidentified passenger at the time had switched seats after Deputy Megan had activated these emergency lights.
Understood. Did they talk to anything else about the switching of the seats?
Deputy Megan asked them how they switched seats, which was not talked about, and why they would switch seats, which I don't think there's ever an answer to that either.
Understood. Did you make contact with this passenger that supposedly switched seats with Mr. Brown?
Yes,
Who was the passenger?
The passenger did not want to identify himself to me.
Mhm.
And he was eventually, his first name was eventually found out to be Bennett.
Did you discuss anything with this individual?
Yes, I asked Bennett if he had been driving, to which he stated he had not.
Understood. Did the deputy banking conduct any testing with Mr. Jeremy Brown?
Yes.
What kind of testing?
Deputy Megan asked Mr. Brown if he would do standardized field sobriety tests.
Mhm.
Mr. Brown refused testing, but consented to the preliminary breath test, which the result was 0.170.
Were there any other testing conducted?
Yes, a blood draw was eventually conducted later on.
What were the results of that test?
The results of that test was.
Objection irrelevant for today's purposes. Oh, withdrawn.
All right, you may answer.
The result was 0.235 gallons per 110 milliliters of ethanol.
Understood. Was the defendant placed under arrest as a result of this incident?
Yes,
What was he arrested for?
it was OWI 4th, failure to install IID and operating after revocation due to alcohol.
So when you say OWI 4th, does the defendant have prior OWI convictions on his record?
Yes, he has 3.
Understood. No further questions, Your Honor. And the state will eventually move to admit the defendant's driving record into evidence. Sorry, the state will also move to admit the defendant's driving record into evidence.
Right. Received.
Like,
You can look at it.
I'll look at it after we,
Okay. All right. Thank you. Let him look at it. Come
okay.
file it. All right. Questions, Mr. Anderson?
Yes, Judge, thank you. Deputy Anton, did you ever see the F-150 moving on a highway of the state of Wisconsin?
I did not know.
And where did you come from as far as when you received a dispatch that Deputy Mangan had someone stopped?
I was north of County Road U on State Road 35, approximately 2 miles north.
All right, and then, so you had to, which way were you proceeding?
I was coming south.
And then, so you proceed 2 miles south. Did you activate your emergency equipment? Do
I did at one point, yes.
you know when?
Deputy Mangan called out the traffic stop and said he had somebody walking into the bar and was not listening to him. So that's when I activated my emergency equipment.
Okay. And once you get to Highway U, I assume you turned west
Correct, yes.
and Highway U is a 2-lane county road.
Yes.
And how long did it take you to get from the intersection of U and 35 to the Gandy Dancer Saloon?
Minute and a half.
So from the time you heard the dispatch, how long did it take you to get to the Gandy?
Oh,
Gandy Dancer Saloon.
5 minutes in there somewhere.
All right, thank you. Now, where did you first see Mr. Brown?
I saw Mr. Brown. He was standing next to Deputy Mangan in front of Deputy Mangan's squad.
And from Deputy Mangan, did you learn that Mr. Brown had already gone into the Gandy Dancer Saloon and came back out?
Yes.
Did you ever notice Mr. Brown's speech being slurred?
Yes.
You did?
I did. I did stand next to Mr. Brown while Deputy Mangan was talking to him. Yes.
Okay. And were you able to observe glossy eyes?
I did.
And did you hear Mr. Brown deny being the driver?
Yes.
Did you go to the hospital for the blood draw?
No, I did not.
So after Deputy Mangan left the Gandy dancer with Mr. Brown, did you ever see Mr. Brown again that night?
No.
How long were you at the Gandy dancer once you arrived?
I don't know an exact time. I would probably estimate about 10 minutes.
This person you spoke to named Bennett, can you describe him as far as his height and weight?
I would describe him as about 5'6", 5'7", and 220 pounds. About 65 years old.
No further questions for today.
All right, redirect.
Just a few, Your Honor. So Deputy Bailey Mangan was the one that observed the Ford F-150 driving on a highway in this county, correct?
Yes.
And upon arriving at the Gandy Dancer Saloon, Deputy Mangan is the one that saw someone matching Mr. Brown's description exit the driver's side, correct?
Yes.
When you did make contact with this passenger named Bennett, was he sitting or was he standing?
He was sitting in the front passenger seat.
So he had the door closed and you just got a little bit of a glimpse of him.
Correct.
No further questions, Your Honor.
Any redirect?
Nothing
Or
else,
recross?
Judge.
Sorry. All right. You're free to step down. Thank you. You are released. Any further witnesses?
No, Your Honor.
Witnesses today?
Excellent. Thank you. Based upon the information and testimony that the court has heard from Deputy Gavin Antone, the court will find that there is reason to believe that a felony was probably committed and was probably committed by Mr. Brown in Burnett County. The court will find probable cause and will bind the matter over. Information, Mr. Vila?
Thank you, Your Honor. I'm going through and filing the information as we speak. It will mirror the criminal complaint.
Would you like to proceed with an arraignment or set for another date?
I would like to have that set for another date.
All righty.
Tell me where we go.
I can do March 4th at 10. And video conference Zoom is fine. Does that pen work, Mr. Brown?
Oh, yes, ma'am, it does.
Okay, thank you.
I guess I didn't check it.
I've been told it wasn't working and I need to order a new one. I need to write that on a list.
March 4th at 10 will work.
Excellent. March 4th at 10. Again, Zoom is approved. Are you still on Howe Road?
Yes, ma'am.
Telephone ends in 8185.
Yes, Your Honor.
We're good to go. You can come up here and you will get a written notice.
Okay.
So you can write it all down, do what you want to, but you can get a printed notice here as well. If there's nothing further, we are adjourned.
Thank you.
I will go on the record in the matter 25 CF 120, State of Wisconsin versus Kendra Benjamin. The state appears through Assistant District Attorney Jose Vila in person. We have Ms. Benjamin appearing by video conferencing with approval of the court. We have her counsel, Joseph Rosenthal, also appearing by video. We're set today in this matter for a plea and sentencing. The parties have reached an agreement. Can you please recite it on the record, Mr. Rosenthal?
Thank you, Your Honor. My client is going to enter a plea of guilty to count 1, possession of narcotic drugs at or near certain places. The parties will have agreed to enter into a 12-month deferred agreement. The terms have been reduced to writing and signed by all parties. At the end of the 12 months, if she is successful, state will move to dismiss count 1. I will note that there's been a stipulation that paragraph 10, as far as the AODA assessment and follow through on treatment, has already been satisfied based on treatment that postdates the date of this incident. I did just send the state an email asking if we could dismiss rather than dismiss and read in counts 2 and 3. So I will defer to Attorney Vila on that issue.
That's fine. We can dismiss it, given that it's a deferred for count 1.
Totally fine. Okay. All right. And that's the agreement that you've reached, Ms. Benjamin?
Yes.
I have in front of me 2 documents. One is a deferred judgment of conviction document, and one is a plea questionnaire waiver of rights form. Did your attorney thoroughly go over those documents with you?
Yes.
You understand everything completely?
Yep.
He essentially read them to you word for word,
Yes.
and you signed both of those documents.
Yes.
You're 26 years old. Do you have a GED or a high school diploma or equivalent?
I have a high school diploma.
Excellent, thank you. And you can read, write, you understand the English language. Do you understand the charge that you're pleading to
Yes.
and what the state would have to prove, as well as the maximum possible penalty?
Yes.
Do you understand that because you're charged with crimes, you're entitled to constitutional rights, and each of those rights is listed on the first page of both of those documents? Do you understand those rights?
Yes.
Did your attorney thoroughly go over those rights with you?
Yes.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
You understand, or do you need me to go over those rights with you in any more detail?
No.
You understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
You understand that you would have a right to be here in person for this plea and sentencing, but you're appearing by video, thus waiving your right to be here in person. Do you understand that?
Yes.
Do you wish to have this in person, or are you okay with video?
I'm okay with video.
All right, thank you. Do you understand that you're pleading guilty to a felony? As such, you will no longer be able to use or possess a firearm for life if the court enters judgment as to this felony?
Yes.
Do you understand if the court enters judgment to the felony, you wouldn't be able to vote in any election except for tribal until your civil rights are restored?
Yes.
You understand the state would have to prove as to count 1, possession of narcotic drugs, possession of a controlled substance on or near certain places, that on or around August 3rd, 2025, in Burnett County, Wisconsin, you knowingly possessed fentanyl, a controlled substance in the Schedule 1 or 2 narcotic drug, without a prescription. Do you understand what the state would have to prove?
Yes.
You understand that upon conviction, you would face a fine of up to $10,000 or 3.5 years of incarceration, or both?
Yes.
You also understand that because of that enhancer of the possession of a controlled substance on or near certain places, that because this offense occurred within 1,000 feet of a park, the court shall impose 100 hours of community service work with a public agency or nonprofit, and that the court will ensure that you are provided a written statement of the terms of that community service, and you must do that in good faith. Do you understand that?
Yes.
All right. Now, do you understand that the agreement that's been reached is a deferred judgment of conviction, meaning that if you do all of the things within your deferred judgment of conviction, that the matter will be dismissed and you won't have to worry about it again. But if you fail to meet all of the conditions, that judgment will be entered and you will be sentenced on that felony. Do you understand that?
Yes.
And do you understand that it's my decision, my discretion, if I accept that deferred judgment of conviction?
Yes.
You still wish to proceed and enter a guilty plea?
Yes.
Now, did your attorney go over with you what the state would have to prove? And did he go over with you the facts that are alleged in that criminal complaint?
Yes.
For the most part, are those facts accurate?
Yes.
Are you pleading guilty to count 1 because you are guilty of that count?
Yes.
Do you have any questions for the court or for your attorney before I proceed?
So would I have to do community service over there, or like, how would I do that?
Let's just, you wouldn't have to, you can do it anywhere as long as it's anything that I approve. However, let's not worry about that because you're doing a deferred judgment of conviction. You do not have to worry about the community service unless this is revoked and you're sentenced on the felony, okay?
Oh, okay. I was confused, but thank you.
And I do have to ask you to just stop and sit.
Yeah, sorry, I heard my baby.
Okay, all right. So that's at a different date and time. So,
Okay.
all right. So any other questions?
No.
Mr. Rosenthal, may the court use the probable cause section of the criminal complaint along with the statements made by your client to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or promises to you for you to plead guilty to the charge?
No.
You're doing so freely and intelligently. That means you are telling the court you fully understand what you're doing
Yes.
and voluntarily.
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes.
Has he looked at this matter thoroughly?
Yes.
Are you satisfied with his services?
Yes.
Any questions for the court or for your attorney before I proceed?
No.
As to count 1, possession of narcotic drugs, an I felony, near or on certain places, how do you wish to plead?
Guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 1. Counts 2 and 3 will be dismissed outright. A judgment of conviction will be entered today. Argument, Mr. Vila?
Thank you, Your Honor. I believe the joint recommendation in this case is appropriate. This is a personal use case. Ms. Benjamin here is accepting responsibility for her actions today. Furthermore, I think she realized that she needed treatment. She went and took treatment on her own accord after the date of this incident, as Mr. Rosenthal already previously alluded to. And with the terms of this deferred, if she completes it, she gets to earn her way out of a felony. If not, she has that hanging over her head. Given that this is a personal use case, I don't think she's a danger to the community. I would ask the court to adopt the joint recommendations being appropriate. Thank you.
Thank you. Mr. Rosenthal?
Thank you, Your Honor. My client's very young. She's 26 years old. She has entered a plea today. She does accept responsibility. To her credit, she was very proactive in dealing with their AODA issues. She sought out an assessment. She completed 111 days of treatment at Recovering Hope in the Twin Cities. She's been sober since then. She's raising her 2-month-old. I think her record is very limited. I think this is appropriate. Gives her an opportunity to keep her record clean, free of any felonies. And again, there's some consequences hanging over her head if she doesn't.
All right, thank you. Ms. Benjamin, anything you want to add or you want to tell me?
Other than just that, like, I have my other 2 daughters living with me now too, and that, like, I'm sober and, doing what I need to do, and I'm still, just taking care of my kids and getting back on the right path. And I have college and a tarot application for a 49er going my way, so that's it.
I am so proud of you, Ms. Benjamin. Look at where you are right now. Look at what you're doing. You have your girls back with you. You're raising your new baby. You are looking at additional school. You are sober and you are being a very stable and responsible person. And I am so glad to see that. I think this agreement is appropriate. You're doing what you need to do. Quite honestly, it's above and beyond what you would do. So I think that is great. What I am going to do here is I'm accepting the deferred judgment of conviction, but not as it's written. I'm amending it on the record for the parties to know. What I am going to do is I am cutting it from 12 months to 6 months duration. You've earned it.
Thank you.
You're doing all of the great things. You're being a great mom. You're being responsible. You are taking care of yourself. You're taking control of your life. You're looking for a better future, and you're bettering yourself for your children as well as for yourself. You deserve to have a benefit. And so this will only remain in effect for 6 months. Another thing that I'm going to do, you have $250 posted. I am going to direct the clerk to transfer $150 from that bail you have posted over to the district attorney's office to pay that $150 fee. So that's another thing off of your plate. The only thing that you are going to be responsible for doing now is to stay out of trouble. Don't hang with anybody you shouldn't. Don't do the things that rise to the level of probable cause for a crime, and remain sober. And then in 6 months, bam, it's off your record.
Thank you.
All right, keep up the good work. Again, I am so proud of you. Anything else that, go ahead.
Sorry, that was my daughter. Babe, get out of here.
Okay, that's okay. Anything else from either counsel?
Not for me, Your Honor.
No, Your Honor.
Well,
thank you.
hello. What's your name?
Joyce.
Joyce?
Yeah.
Well, you are a beautiful little girl. Be
Thank
proud
you.
of mama. All right. Thank you so much. Keep up the good work.
Thank you. Let go of the cat, babe. You're choking.
What we've just witnessed across these proceedings is a powerful cross-section of the legal system in action, from strategic waivers and procedural decisions to high-stakes criminal allegations, and ultimately, a moment of genuine compassion and second chances. In the first case, a key right was waived under circumstances tied to negotiation strategy. In the second, the court found probable cause in a serious repeat OWI case, pushing it forward toward trial. But it's the final case that leaves a lasting impression. A young woman facing a felony charge, yet demonstrating accountability, progress, and a commitment to change. The judge's decision to reduce the deferred judgment period from 12 months to just 6 reflects not just legal reasoning, but recognition of personal growth and rehabilitation. And if you found this case as shocking and insightful as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.